HIPAA Privacy and Security Training for Capital Pain Institute. My name is Lorinda Holloway, and I'll be helping present the material today along with my law partner, Debbie Heiser. Debbie is really a true veteran of HIPAA privacy and security law. Since its inception, she's been representing clients and on these issues and guiding them, representing them in investigations and in large breaches. She's also provided expert HIPAA testimony in court regarding both privacy and security issues under state and federal law. A little bit in contrast, my work is focused on government investigations for healthcare providers, as well as all types of litigation representing healthcare providers. So we'll tag team this information today and get through all the material. And afterwards, Capital Pain will be sending out a short quiz, and we're confident that you will all do well on it. Okay. I also, before we dig into the information, I want to highlight two of the Capital Pain employees who you all likely already know and probably know them pretty well. They both have HIPAA and privacy related responsibilities. The first one is Jessica Levy. She's, of course, the Chief of Staff. She's also been serving as Capital Pain's Interim Privacy Officer. Lauren Bantow is also now the Assistant Chief of Staff and the incoming Privacy Officer. And with that, Debbie, I'll turn it over to you.
Thank you, Lorinda, and welcome to our training. We're going to talk about HIPAA privacy, and we'll also talk about security to a limited extent as it relates to privacy, because you will have a separate security vendor assisting you with a risk assessment and developing policies and procedures that he will review with you. We'll also talk a little bit about HIPAA's relaxation of the privacy issues in light of the COVID-19 epidemic. Do you need to advance the slide, Lorinda?
There you go.
Okay, so right now we're going to do a HIPAA privacy rule overview for you. And we'll start with talking about who is covered by HIPAA, what does HIPAA require, and when are you required to comply with HIPAA. So who's covered by HIPAA? There are three groups that are covered: healthcare plans, healthcare providers, and that's whether you're a doctor in a clinic or you're a hospital or you're an institute like you are, paying practice. If you are submitting HIPAA transaction codes electronically. So there are some providers who aren't covered, but CPI is covered and most covered entities are covered. And third, healthcare clearinghouses, which essentially means an entity that a covered entity uses to take the existing claims and put them into HIPAA transaction code sets. So what are we talking about when we talk about protected health information? Protected health information is individually identifiable health information in any form or format, including paper, electronic, or oral, that is transmitted by a covered entity, in this case CPI, or a CPI business associate, and we'll tell you later what that means. It includes protected health information, and it includes demographic information that relates to the patient's past, present, or future physical or mental health or condition, the provision of healthcare to the individual by CPI, or past, present, or future payment for healthcare to individuals. That identifies the individual, or for which there is a reasonable basis to believe the individual can be identified using those identifiers. Examples of protected health information, we'll see shortly that there's 18 identifiers that make up what protected health information is. By way of example, Social Security numbers along with the patient's name, credit card numbers along with the patient's name, driver's license numbers, personal information, research data, and individually identifiable health information. If a covered entity or an employee of a covered entity improperly uses or discloses PHI. And that disclosure presents the risk of identity theft, invasion of privacy, or can cause harm and embarrassment to the staff, patients. I'm sorry, I kind of didn't do that right. If there's an improper use or disclosure or a risk of identity theft, invasion of property, that will and can cause harm and embarrassment to CPI staff, patients, and CPI. Breaches of information privacy can also result in criminal and civil penalties against both CPI and an individual who improperly accesses, discloses PHI. And under Texas law, if you are licensed and you violate HIPAA, a report will be made to your licensing board, and the licensing board can also take action to sanction you. As I mentioned, there's 18 identifiers. I'm not going to read those for you because you can see them, but you can see it's not just, it's everything, any number, device, medical record number, biometric identifier, fingerprints, or voicemail. Voice prints. And it's these identifiers that also indicate that you are a patient of CPI. So these individual identifiers in and of themselves, without connecting the individual to a healthcare provider, would not be protected health information.
Debbie, I have a question here really about the email address. So let's say it's a patient who has a really generic email address like John is here at gmail.com. Why would something like that help us understand why something like just that email address would be protected health information, or is it?
Good question, Lorenda. And that's what I was trying to say. So an email, I can post my email anywhere, my email address, any place I want. I can send it to whoever I want. My email that kind of says who I am, but at least my first and last name, basically is not protected health information unless it is being, like if I send by email, if I send healthcare information to a CPI physician, that I can send my protected health information to anybody I want, and that is not covered by HIPAA. HIPAA doesn't control me as the individual, doesn't cover me. However, once the CPI physician or provider or administrator responds to that email, you have one of the 18 identifiers connected with the fact that that person is receiving care from CPI or from that specific provider.
And so it's really the connecting of those two things that make it protected health information. So that's right. And so I think that's why, from what I understand from working with CPI, is that's why it's a practice at CPI not to ever really respond in substance to a patient who emails about their healthcare information, but rather just sort of acknowledgement and then maybe logistics on follow up, but not specifically commenting on the patient's medical care.
And I think that's a very wise practice from a risk management perspective. And because under Texas law, which we'll see soon, if a healthcare provider is going to communicate with the patient via email, you have to have a consent form before you do that. And in your policies and procedures, and we've talked to Jessica and Lauren and gone through the consent form, that needs to be used before you ever respond to a patient's email. And there's a reason for that under Texas law, is because Texas law says you have to have authorization to communicate with a patient electronically.
And I think those are actually now, that particular email communication consent form is now on the Capital Pain website under patient tools.
Okay, that's right. I forgot. Thank you, Lorenda.
Okay, next slide.
Really think it's important, we focus a whole lot on electronic PHI because that's where a lot of the breaches come from and a lot of the regulation is addressing. But you have to remember that protected health information, again, it can be a piece of paper, it can be oral discussions in the hallway about a patient when the doctor's going in and out of the office, or it can be electronic. So it doesn't matter the format. And you really have to keep that in mind. Be careful if you go to a cocktail party and talk about a patient, that's still protected health information, and that could be could be subject to sanctions. So a little reality check here. The enforcement of HIPAA is Congress, when Congress passed the healthcare, what is it called? Health Information Protection, Privacy or Health Information Protection Accountability Act. Basically, Congress delegated enforcement of that act of HIPAA to the U.S. Department of Health and Human Services. The HHS in turn delegated that to the Office of Civil Rights. And the Office of Civil Rights in the United States is divided regionally. Typically in Texas, our office is the Dallas regional office. However, we've learned that a disgruntled patient can file a claim any place, regardless of where they're living or where they were receiving services. In addition, Congress delegated to the Department of Justice the authority to investigate criminal violations of HIPAA, which we'll get into, and to impose sanctions. So I have this case here because I think it's kind of interesting when we talk, to backtrack again to the previous slide. Affinity Health Plan, Inc. was sanctioned by OCR for $1.2 million. And the reason was they had an old copy machine, a Xerox machine, and they turned it into the entity that they leased it from, and they forgot to wipe it clean. And there was PHI of over 344, 579 patients. And this honestly, I don't think that the industry or the lawyers who represent the industry really were thinking about these machines and the fact that they do record. And so this was a big wake-up call for understanding it doesn't matter where the PHI, what format, even if it's on a machine, so like an image machine or a recording or a fax machine, it is still PHI, and the covered entity is still required to destroy that, wipe it out, or destroy it as HIPAA requires. All right, so we're switching hats for a little bit. Now we're talking about when you can use or disclose PHI. We've talked about who's covered, and now we're going to talk about what it means and when. So an employee, a CPI employee, can access or disclose a CPI patient's protected health information when it is part of his or her job duties. If an employee accesses or discloses PHI without a job-related reason, the employee violates CPI's policies and HIPAA. So you have to have a job reason for doing that, for going in and using or disclosing accessing or disclosing the PHI. It is never acceptable for an employee to look at PHI just out of curiosity, even if you don't intend to harm the person. In this these are examples that kind of came out from real cases. So, you know, an employee says, oh, I knew that somebody died. I wanted to send a get well, or somebody was very sick. I want to send a get well card. So I went in and I got the address to send the card. Can't do that. That's not a job duty. It also makes no difference if the information relates to a high profile person or a close family friend or family member. All information is entitled to the same protection and must be kept private. So, for example, you may remember Farrah Fawcett, and Farrah Fawcett had cancer, and I believe it was through MD Anderson. I'm not sure if that's true. That's my memory. And she came into the hospital, and immediately all the staff were looking in to see what was going on with her, and you know, it was kind of intriguing. It's Farrah Fawcett. That's a violation. It's also a violation for any of us to go into, any employee of CPI to go into a medical record because you happen to know that person, it happens to be your ex-husband's new wife, or you know, somebody you're curious. You can't do that. And there have been penalties for people doing that against the covered entity. Be aware that if you access PHI of someone you personally know or who is involved in a divorce or custody, with the intent to use that information for personal gain or advantage, that could be interpreted by the Department of Justice as a criminal act. Improper pay. Go ahead. Go ahead.
Yeah, so I have a couple of questions. So this really means, for example, I mean, a capital pain cannot even disclose to a patient's spouse the records of the patient, right? I mean, it goes that far. Now, a lot of times, of course, as a practical matter, patients are showing up with a spouse or a loved one. Well, the patient's right there, so they're necessarily consenting to the person they brought with them to hear the information. But if they were to receive, if a patient's husband or wife or spouse came in and said, I need to get a copy of my spouse's records, you have to have an authorization for that.
Yes, and yes, that's correct, Lorenda. And it is really important. And again, sometimes if you have any questions about whether somebody should have access to the record, that's a good time to pick up and call your attorney. For example, just because I'm there with my father. My being there with my father, who's the patient, allows the doctor to talk to me because it's implicit consent. I'm sitting with my dad. However, I can't just say I would like to see the records and have the doctor give me my dad's records. My dad has to sign an authorization to give me those records. You either, if you're a minor, it's the parent or the guardian that can get the records. If you're an adult, it has to be authorization unless it's a medical power of attorney and a physician has essentially said the person has a terminal condition. And this becomes really important because a lot of family members get very angry about that. And interestingly, under HIPAA, you are allowed to do that. But under Texas law, you're not. Under HIPAA, you can talk to family members, you can give them the records, you can do whatever you want, but that is not permissible under Texas law. Okay. I guess we weren't talking about when, we were talking about what. Now we're talking about when. So when can a covered entity disclose PHI? Obviously for treatment purposes. Obviously for payment purposes, with a caveat that with payment, you are not allowed to just give over to the insurance everything. You're allowed to give only what's necessary to pay that bill. So for example, if I come into CPI and I say, I am going to pay for this service in full in cash, and I don't want you to tell my insurance company that I was here today or the reason I was here or what treatment I got or what medication I got. I'll pay for all of that in cash. You cannot disclose that to the insurance company. There's a concept called minimum necessary for the purpose. That does not apply to treatment. Obviously, the people who came up with HIPAA didn't want to interfere with the medical judgment of the doctor, so they didn't say when you're doing treatment, you have to think what's the minimum necessary information. But for payment, you do have to do that. And there's that one caveat again with payment that if they ask you not to do it, you can't release it. There's also a category that's generally called healthcare operations. And healthcare operations include using protected health information, for example, for population health studies or treatment and quality assurance, things that are related to the practice of medicine but aren't healthcare. This area gets very complicated, and if you want to use protected health information for healthcare operations outside of CPI especially, again, you need to talk with your legal counsel before you agree to do that. Finally, there's a category that allows you to disclose when it's permitted or required by law. And we're going to talk a lot about that as we talk about COVID and some other things. And I want to also make, because we don't address this separately, when Lorenda and I were doing this practice of this training, she asked me the question of could CPI go into to patients' medical records to identify patients who could benefit from a new drug or a new pain medicine treatment. And that's a very good question, because if that is considered under both HIPAA and Texas law as marketing. and it's considered targeted marketing. And you need authorization before you can do that. So you cannot go into an identified group of patients' records for marketing purposes. You can, however, if you wanted to let all patients know about this drug, even if they're not patients who are going to use it. You could send a newsletter to all patients. You could post notice at the clinics or the offices about the drug. You can talk to the patients who are using that drug when they come in for a visit or for checkup or to get medications. You can talk to them face to face, and that's not considered marketing. So that was an important question from Lorinda. I did not put it in the PowerPoint. Okay, back to the concept of minimum necessary. So a patient's authorization is required, as we've talked about, to use or disclose protected health information. When a use or disclosure of PHI is permitted via patient authorization, HIPAA still requires only the amount of PHI that is minimally necessary to accomplish the intended purpose for the use or disclosure.
And
so what? Yeah.
I understand that capital pain, in their electronic health record, not everyone has access to every part of the record, and it sounds like that's the reason that those restrictions, to the extent they're there, are in place. Does that make sense? Like that it's complying
Yes, that's
with the necessary requirement.
That's correct. And when HIPAA first became, when it was published and groups started to comply with it, there was an initial requirement for all healthcare providers that you look at your practice and you look at each category of employees, administrative, providers, support staff, nurses, techs, physical therapist, or whatever, and you decide categorically what level of access each of those job categories should have to perform the essential functions of their job. And that was done. CPI has indicated that they've done that. And if there's a violation by an employee in that category, then that has to be investigated, and that could be sanctionable by the Office of Civil Rights. Okay, we're going to talk a little bit about COVID, given the reality of this pandemic and the fact that we're all working at home. On March 17th, the Office of Civil Rights issued guidance on how covered entities can comply with HIPAA and the privacy rule and still disclose protected health information about infected individuals with COVID-19.
And we should say, Debbie, a lot of us are working at home, but of course the healthcare providers are definitely still.
That's true. That's absolutely true. Yeah, thank God for the healthcare workers who are still working in the clinics and hospitals, for sure. So that they relax the HIPAA rules, but it's not a carte blanche, ability to go and say whatever you want. It is limited to dealing with a person who is infected or is at risk of being affected. And it is related to disclosures to law enforcement, paramedics, first responders, public health authorities, other healthcare providers, essentially essential providers. And this is not a new rule. If it's basically, you can disclose for treatment, and you can disclose as required by law, which we've always been able to do. They've just relaxed it a little bit where you don't have to. The thinking is you're dealing with an emergency situation, and they're just saying just report it to the healthcare oversight agencies, report it to any first responders, report it to medical providers who might be at risk. So it's a relaxation. Texas law has always had a ability to disclose in a public health disaster, but again, you disclose it to people who, like if you have a communicable disease, you disclose it to the Department of Health and Human Services, or you just disclose it to a first responder, again, who is at risk of being infected. So it's relaxed. We don't know how long the government's going to allow us to keep that relaxation in place, but I'm sure we'll get plenty of notice when they decide they're going to go back to a more strict interpretation.
And when you say relaxed, you just mean we're with respect to sharing information
Yes,
with law
yes,
enforcement and other providers in this sort of more emergent world. You just mean because it's so rare that we would even ever have a public disaster, we're sort of in that special section of HIPAA that allows this relaxation. But once there's no longer a public health disaster, it will be we'll be back under sort of regular conduct under HIPAA.
correct.
And
And
talk separately about telehealth, and that literally specifically has some relaxations. But this is relaxed in the sense that we're acting under a section of HIPAA that's always been there. It's just rarely triggered because we've got this.
that's correct. We've always been able, in fact, required to report to the FDA or the CDA or the public health entities if you have a communicable disease, right? Relaxing also in my mind means that you don't have to really engage in the analysis of is this an imminent threat. Obviously, given how COVID-19 is transmitted, they're basically assuming if somebody's positive, you report it as you're required to. So it's a little bit it's just a little bit more leeway in reporting fast, I think, to prevent the spread of COVID-19. Okay.
Kind of bumping through several slides
yeah.
because I think that's what you've been covering.
Yes. If obvious, okay, so you know that if somebody tests, you've got to report it to the state and to the CDC. The other, I think it's important to remember too that under the under Texas law, you report it to the Texas Department of State Health Services. So that's not a change. And you can report under normal times if you believe that a patient is at an imminent risk of harm to themselves or others. Healthcare providers have always been able to call medical or law enforcement personnel to address the imminent threat, and that hasn't changed. That's still the law. So if you have somebody who has COVID-19 and is taking opioids and you think they're going to be out there and not taking care of themselves in a way to prevent spread, you would have a right to call law enforcement or medical personnel if you believe it's an imminent physical injury to the patient or another person. Okay, telehealth. We understand that CPI is doing some telehealth, and I think the importance on this here is that HIPAA has used some definitions of what telehealth is: electronic information telecommunications technology to support and promote long-distance clinical healthcare. The COVID guidance has basically helped you to identify what method you can use: audio, text messaging, video conferencing. There's some you don't need authorization under HIPAA or now the licensing boards. To my knowledge, most of them are not requiring authorization.
And so, Debbie, unlike the reporting or sharing of protected health information, for example, with emergency healthcare providers or with law enforcement, where we're in this, hey, this is a pandemic, so you can more freely share this information. With respect to telehealth, the changes we're talking about are, in fact, temporary actual changes or formal relaxations of requirements under HIPAA so that folks can perform telehealth, telemedicine, and in order to better protect everyone and to reduce the spread.
Yes, and and I think also implicitly so that the whole healthcare system doesn't fall apart. I mean, if you can't physically bring people into your office if they're contagious and there's other patients waiting around. The guidance that we're not going to go through in explicit detail for you, but the guidance basically tells you what kind of programs that you can use and what you shouldn't use. I think the most important piece here for you to know, because I know you deal with substance use here, is SAMHSA, which is the agency that regulates substance use disorder treatment and records, has also said that you can disclose this now in a bona fide emergency situation. So before, it was a black and white rule that you could not disclose substance use information without authorization. That is no longer required for the period of the pandemic. Okay. And as we said, OCR will issue notice to us to the public when they're no longer going to allow these relaxed rules. Again, we're not going to go in big detail for this because we know that you're not, the people who are doing it are not doing a lot of it, but the biggest takeaway in my mind from this guidance for healthcare providers is, although you can use things like Zoom and Skype, FaceTime, you're still required to protect the confidentiality of the encounter and the interaction. So you have to still do telehealth in a private place, in your office, or your home office, or in the clinic or in the hospital. But you have to make sure that the setting is private and do everything you can so that that interaction is not being observed or overheard. The OCR has said in the guidance that if they find out that a covered entity is acting in bad faith in the provision of telehealth, that they would still consider a penalty. Otherwise, they're not looking at any penalties. That's another point, Lorinda, is in relaxing the rules, they basically said they're not going to impose any penalties for the use of telehealth unless it's in bad faith. And that means that you're trying to steal the identity of somebody, or you're explicitly doing it in a public place, or you're using it for something in the judgment of the professional really is not appropriate for a telehealth interaction.
And we've skipped through several slides rather quickly, but all of these are essentially frequently asked questions that have been posted by the Office of Civil Rights. And we've sort of condensed some of the answers, although it doesn't look like it on this particular slide, which is very long. But these are the common questions that folks have. But again, because Capital Pain is doing rather limited telehealth, we're not going into a ton of detail. But you did mention earlier the types of products that can be used appropriately during this pandemic for telehealth. And I think this rule is probably applicable for proper telehealth usage, even when we're not in a pandemic. But it's important that the technology that's used is what's called non-public facing, meaning things like FaceTime, Facebook, Messenger, WhatsApp, Zoom, Skype. Those are all fine, but because they're non-public facing. But public facing products like TikTok, Facebook Live, and products like that where others can see, obviously would not be confidential, and therefore are still not permitted even during the pandemic.
Right. And in addition to this HIPAA guidance for people that are licensed, there's also guidance on all the licensing board websites. If anybody in CPI has questions, they can be directed to their licensing board website or call Lorinda. But
and speaking of the Texas Medical Board, Governor, and this is specific to Texas, other states have done similar things, and even the federal government has taken some action here as well. But there is currently a waiver in place for chronic pain during COVID-19, and specifically, Governor Abbott approved the medical board temporarily suspending the rule that prohibits prescription of Schedule II drugs via telemedicine. And so there's a waiver in place that, and again, this is more restrictive than what the feds in some other states are doing. In Texas, though, this waiver of this rule temporarily, it only allows refills of a valid prescription for treatment of chronic pain by a physician with an established chronic pain patient. So that's an important distinction. If we were looking only at federal law, it would allow the physician to establish the physician-patient relationship via telemedicine and then prescribe. But Texas law does not permit that. And of course, that's because of the opioid crisis that's kind of in the backdrop of all this. And in fact, the governor mentions the opioid crisis in his executive order and says, due to the seriousness of the opioid crisis and the need to ensure that there's proper oversight of chronic pain management, the suspension of this rule that prohibits giving Schedule II drugs over via telemedicine is only in effect, initially was only in effect until April 10. Now that's been extended to May 8, 2020, and everyone I think is curious whether that may well have to be extended again, and that's just a wait and see moment. Okay, so I think we're going to switch and talk about breaches of HIPAA and of the privacy and security laws now, and I'm going to have this section and Debbie may jump in with questions if she has any. But a breach, so important to understand what is a breach. It occurs when information that by law must be protected is either lost, stolen, or improperly disposed of. And that's the case whether it's paper or electronic. If information is hacked and if it is communicated or sent to others who don't have an official need to receive it. And that includes that cocktail party conversation about the patient would be a breach. Interestingly, federal law and Texas law are a little different when it comes to defining what it means for there to be a breach. Federal law is really broad. It talks about an impermissible use or disclosure under the privacy rule that compromises the security or the privacy of protected health information. So that sounds like kind of anything, use or disclosure, and if it compromises security or privacy. Texas, on the other hand, defines a breach as the unauthorized acquisition of computerized data that comprises the security, confidentiality, or integrity of what it calls sensitive personal information maintained by a person, including data that's encrypted if the person can get access to it, if they can decrypt it. So those are slightly different definitions and interesting. And Debbie, I don't know if you have any points to add there. Feel free to jump in.
Yeah, the word compromise is interesting under both Texas and HIPAA. Under HIPAA, it used to mean that there was a substantial risk to identity theft or financial theft. Now it's basically there's a breach risk assessment that we've provided to Jessica and Lauren to be used. You have to go through what the consequences of the breach are and make a determination whether the breach is low, high, or medium. If it's higher, if it's medium or high, then you've got some duties to notify patients and notify the Office of Civil Rights. And that's much more detailed than we're going to get into today. But if it's over 500 patients, you're required to notify the media and notify Office of Civil Rights immediately.
Okay, and then we're going to talk about some statistics around breaches. So 81% of healthcare organizations have experienced a cyber attack. Only 54% consider themselves really ready to defend themselves, which is an interesting contrast. 40% of consumers said they would leave a healthcare system that had been hacked, and more than 50% said they would hesitate to use a health system if it was breached. So obviously there's a ripple effect that happens from a pure just business and generation side of things and the ability to maintain your patient base. If you have significant breaches, it really does hurt business and hurts patients. A breach back in 2015 was estimated to cost about $402 per patient. In other words, to do all that has to be done once there has been a security breach, it is super expensive, and that much per patient adds up quite a bit if you're talking about hundreds of patients.
And I'd like to say just one thing, Lorinda, with respect to breaches. The way the Office of Civil Rights finds out about your violations and breaches of HIPAA is when you report it, when you or a patient reports a breach. And they say they're going to investigate every breach. Obviously, they're not able to do that under all the current situation, but they will, when they investigate, there's a wall of shame at the Office of Civil Rights where your name and the facts of your breach go up, and then they go up on their enforcement actions on the internet. So, I don't know how many patients look at that, but it doesn't remain private when you have a breach.
Yeah, interesting. And here's a good example of that because these were all available from that wall of shame. These are large enforcement cases. I won't read through every single one of them, but these are even as far back as 2016. The penalties were really high. Advocate Healthcare Network at $5.5 million. Excuse me. And those are a list of several other large enforcement actions with huge penalties.
And there's a recent one against MD Anderson where a research professor took a thumb drive and lost it. And then right after that, they had another breach of a stolen laptop or lost laptop, and they got penalized $4.2 million.
Yeah, and so those were large penalties for breaches of significant pieces of data. It doesn't have to be a breach of a lot of data for there to be significant financial penalties and implications. And this is something that the Office of Civil Rights is very, very focused on right now in 2020. And this was the kind of the beginning of it. These two cases right here, Bayfront and Corunda Medical, were in 2018 and 2019. Both of these enforcement actions, investigations, and then settlements, essentially, with OCR came as the result of a single patient complaint. With Bayfront, the patient initiated the complaint because the facility had not responded to her request for a copy of her child's records, and she submitted a complaint. And it cost Bayfront $85,000 to settle with the OCR, the Office of Civil Rights, and they had to have a corrective action plan, which, if I recall correctly, was for a 1-year time period. And that means you're essentially having to demonstrate to the Office of Civil Rights that you're taking certain corrective action, and you're having to demonstrate it to them. It's like basically having to show them your homework over the course of a year, and it's intense, and that can be expensive. Same difference with Corunda Medical. A patient initiated a complaint because she had not been provided with a copy of her records in the electronic format that she had requested, despite making repeated requests. That also resulted in an $85,000 settlement and a corrective action plan. So again, it doesn't have to be a breach of security where 500 or 1,000 patients' information was improperly accessed or disclosed. Just a patient not getting the access that they requested can lead to significant penalties. Here's another OCR fine, recent one in 2020, where a gastroenterology practice was fined $100,000. They had failed to comply with those security requirements to conduct a security risk assessment and implement a risk management plan. And so OCR noted that this is a failure characterized as part of a, quote, unacceptable and disturbing trend in the healthcare industry. So as you can see from comments like that, over time, there's been more higher and higher enforcement through the Office of Civil Rights on HIPAA and privacy and security breaches and violations. So like with most things in healthcare, it's like the government tells you, here's what we're going to require of you. Here's what we are now requiring of you. We're going to be enforcing it. And then over time, they really ratchet up the focus. So they give you time to implement and get this stuff laid out straight. And then at some point, they do really start bringing down the hammer. And that is where we are, I believe, in the current state of things with the Office of Civil Rights. The penalties for non-compliance there, you can read that detail, but essentially they're in a tiered fashion. If you look at tiers 1 and 2, they seem almost somewhat innocent. I would call them sort of oops moments. But look at the significant penalties that they can carry. So in tier 1 or 2, a covered entity or individual in tier 1 did not know, and by exercising reasonable diligence, would not have known the act was a HIPAA violation. So just the fact that they didn't know something was a violation led to and there was presumably also a breach, can lead to that range of penalties. And then, of course, tier 3 and 4 are more significant. And did you have a comment, Debbie?
No. I do, actually. It's important to understand that if CPI has a breach, and let's say that a patient requested electronic records and they weren't provided, and let's say that the privacy officer who would be responsible for investigating that wasn't made aware of that for 6 months. HIPAA considers a breach to have been discovered. That's the key term. A breach is discovered when any employee of CPI knew or should have known about the breach. So, and you have 60 days from the date of discovery to report that to the Office of Civil Rights unless it's over 500 people. So it's really important from a compliance standpoint that anybody at CPI who sees or knows there's a breach has to report it immediately to somebody who's in a position to take action, because you'll miss the discovery deadline and you'll have 2 problems instead of 1.
You said on that quote discovery deadline to report up to the Office of Civil Rights. That's if it's over 500 patients at issue.
You have 60 days to report a breach if it's less than 500 people. You have to report the breach immediately if it's over 500 people. So all breaches get reported to the Office of Civil Rights. It's just if it's 500 more, it has to be as soon as you discover it. If it's less than 500, it's 60 days from the date of discovery.
Got it. Thank you for that added information. Okay, so and I'm gonna go through this slide rather quickly just because we're trying to keep this webinar under or right at an hour. So, but here's just an important point that individual employees and not just the covered entities, so not just capital pain, for example, for whom the employees work, are subject to sanctions. In other words, it's the entities, but it is also the individual employees. And we have an example there from Seattle Cancer Care Alliance, where someone was pled guilty and served a 16-month prison sentence and had to pay back both the impacted credit card companies and the patient from whom the person had stolen PHI. So your duties as a CPI employee in the event of a breach, part of your responsibility, as Debbie was saying, is to report a privacy or security breach to the HIPAA privacy officer. And that's both, right now, Jessica is the interim privacy officer, and then Lauren is the incoming privacy officer. So you need to let one of them know. Yes. CPI is updating its breach risk assessment tool in its policies and procedures. So there'll be more coming on that. And of course, capital pain cannot threaten or take any retaliatory action against anyone for exercising his or her rights under HIPAA or for filing a HIPAA report or complaint. Okay, so I think, Debbie, I'm going to turn this back over to you to talk about patient rights.
All right, and we're going to go through this pretty fast because we're running out of time, but under HIPAA, patients have certain rights, and they have a right to receive a copy of your notice of privacy practice, which is posted on the CPI website, that tells patients how their information is used and disclosed, when authorization is required, when it's not, their right to file a complaint and how you do that, etc. I have a right to ask for a restriction. I can come in and say, I don't want you to tell my primary care physician that I'm receiving pain meds. And CPI is not required to honor that restriction, but you have to document why you're not honoring it. And you're going to get a lot of push from primary care physicians that say it's really important for me to know that, but a patient does have a right to ask that you restrict that. You have a right to inspect and inspect and receive a copy of your records electronically. You have a right to amend or correct your record if it's not accurate. And that doesn't mean that you destroy a record. It means that you go in and you put a line through it, or you do it on the computer, however you do, but say, this is amended and here's the amendment. If the doctor says, I'm not going to amend that because that information is correct, then the patient has the right to say, I want you to attach this addendum to my record so that whenever that record goes, at least the next person has my explanation of what the information is. So you either amend it or you let them attach or you attach an addendum to their record. You always attach an addendum. You don't alter a record. But if the doctor says, I'm not going to correct it, then you let the patient put their own addendum, give you their own addendum to put into the record. They have a right to an accounting of disclosures for purposes other than treatment, payment, and permissible healthcare operations. So I have a right to ask CPI every year, please give me a list of everybody to whom you have disclosed my protected health information. And that bumps CPI into the duty of knowing and keeping accounting records so that you know who it was sent to and can provide that accounting. You have 60 days to provide that accounting. And finally, patients have a right to file a complaint. And the Notice of Privacy Practice, again, tells them how to do that either with CPI or with the Office of Civil Rights. And I mentioned earlier that if a patient pays in cash in full and asks you not to release the information to the health plan, you have to comply with that request. All right. Just so that you are aware, under HIPAA rules, if a patient asks for their records in paper or electronically, you have 30 days to provide those records. Under Texas law, you only have 15 days. So as soon as you get the authorization under Texas law, that clock starts running or the request, and you only have 15 days. Okay, we're not going to go into a lot of detail about business associates. You just know that because this is something the administrators will deal with, but whenever CPI uses a third-party vendor and that vendor can access or create or maintain or transmit your medical records, that vendor has to sign a business associate agreement that obligates the vendor to the same privacy and security duties that CPI has. And again, the security rule, we're not going to go into much detail because you're going to have other people that are going to train you on that.
And so HIPAA security rules address really safeguards that need to be in place to protect patient privacy. So you can think of it almost like actual security for your home. The idea is the doors and the windows need to be locked and the alarm system needs to be on, so to speak. So there are security standards and safeguards. Capital Pain, like all covered entities, is required to have administrative, technical, and physical safeguards to protect privacy, and those safeguards need to protect against both accidental and intentional unauthorized use or disclosure in their computer system. This includes having practices such as encryptions, document shredding, locking doors and filing storage areas, and use of passwords and codes for access. So we're going to talk about what's required for mobile devices. To start, Capital Pain's requires that written approval has to be granted by the privacy officer before you can store protected health information on mobile devices. And encryption is required when an employee sends or receives PHI or sending it to a destination address outside of CPI. And remember, Texas law requires authorization from the patient to release their PHI electronically. So that's why there's an email consent form now on Capital Pain's website under the patient tools. When you're traveling, working from home, or using a mobile device, employees whose work involves the transmission of protected health information must encrypt the data unless they're using a VPN or virtual private network connection, and they transmit the data only to a destination within CPI. So your own, if you are emailing, for example, or using a mobile device and emailing with Jessica on your Capital Pain email account, that's going to be a virtual private network and have its own protections. But if you're going to be emailing to a different destination, then that's different. It needs to be encrypted. Here's more mobile device practices you need to know. Employees must utilize the following security controls. You really need to have strong power on passwords, automatic log offs, the display screen lock at regular intervals while the device is inactive. So you don't want to have your phone locked down and be password protected and not have your unlock status, be for an hour or something like that. It needs to be shorter than that. And encryption is a requirement. So you never want to leave your mobile device unattended in unsecured areas, and of course, immediately report the loss or theft of a mobile device. And I know for a lot of entities, they're able to remotely wipe out a mobile device. And remember, for any mobile device, encryption is the best defense. And Debbie, I don't know if you have any comments or anything you want to add.
No, I think I think it's just really important to make sure that if you have a mobile device in your car and you go to a restaurant, make sure you put it in your trunk and lock it, because there have been things stolen out of cars.
Here's more good practices, particularly for your mobile devices. Do not open email attachments if the message looks the least bit suspicious, even if you recognize the sender. So when in doubt, throw it out is sort of a good standard to apply. Do not respond to spam, just discard it or delete it. Be sure to research applications before downloading. And we inserted an example that was from a client, so we've redacted the from and to part of this email. But if you look and read the email content, well, the subject line says, please install this important update. Please click on the link below to update your electronic health record system. The system needs an update to be ICD-10 compatible. Well, that turned out to be a phishing type of email. So you really want to be careful about just clicking and downloading things that you haven't researched and know to be secure or appropriate. Password control is important. Use strong passwords where possible. Characters, combine letters and numbers and special characters, and of course change your password at least every 45 to 90 days. It is most definitely a violation of Capital Pain's policy to share your password with anyone, so don't do that. And you can see the little picture down there, the password 123456. Clearly, that's a really bad password, so don't do that. Here is a reality check, an example where University of Rochester Medical Center, a physician had misplaced an unencrypted USB drive that had information of 537 patients. And it included demographic identifiers as well as diagnostic information. And because of his negligence, the medical center had to notify all individuals affected by the breach, had to disclose to the Attorney General and to HHS, and it triggered, of course, the possibility of further investigations and large fines. So, again, some takeaways here: avoid using external devices to store sensitive information. If you have to do it, and you're going to use like a thumb drive or a flash drive, for example, encrypt or password protect and encrypt would be ideal. And you want to use a portable storage media like that only to transport information, not to like permanently store. So there shouldn't be laying around Capital Pain or in your home or anything an external thumb drive with patient data on it that you just keep around because it's convenient to have. Preferably you're not doing it at all, But if you're going to put information on one of these mobile devices, like a flash drive, just do it to transport the information, and then the information needs to be wiped from it. And I thought this was
Sorry.
go ahead.
If you have a thumb drive and you've forgotten it, and about 3 years later you find it at your desk or something, don't just throw it in the trash, because somebody could pick it up and plug it in their computer, and that's a breach.
And I thought this was a good tip. If you're going to use a flash drive, consider attaching it to your keyring because you're less likely to misplace it. So I thought that was a good tip. Okay, communication in public areas. In essence, do not discuss sensitive information or public or private health information in public areas. So you want to be careful about conversations in semi-private rooms, in waiting rooms, in the corridors, elevators, stairwells, open treatment areas. We're all human. You're leaving work, you're talking with your friends about your day, but you've got to remain mindful of patient privacy. There's some other privacy safeguards. And these have to do with really just imagine if you were an investigator for the Office of Civil Rights and you're going to walk into Capital Payne's offices. Once you get back into the patient area behind the front desk, what is it you're going to see? Are there going to be papers, out on the table or on a counter or sitting on top of a copy machine, or are the items locked away where they need to be? Either locked away or, not out and openly visible. So during work hours, you want to place written materials in a secure area that aren't, in obvious view or easily accessible by unauthorized folks. Don't leave materials on desks or counters or in the conference rooms or public areas. Do not remove PHI in any form from the designated work site unless you're authorized to do so. And absolutely do not take photographs in patient care areas, and certainly not of patients' medical records. And in fact, I just got a case dismissed, but the foundation of it was a student who was interning in a hospital. In order to get her homework done, had taken a photograph of a patient's record. She claimed that she, of course, already supposedly deleted the photo, and she claimed it had no protected health information on it and that she just needed basically a form. But in essence, she got kicked out of her physical therapy program because that hospital had to take that breach very seriously, and it caused them a lot of heartache and work that had to be done because of that breach, and they simply did not want someone who, in fact, had been properly trained to have gone ahead and done that. So don't use photographs, don't take photographs in the patient care areas or of their records. Okay, how to dispose of sensitive information that's in a tangible format. The bottom line here is don't put things in a regular trash can. If it's electronic, it needs to be wiped appropriately. If it's hard copy, it needs to be shredded. There's more on physical security equipment such as PCs, servers, mainframes, etc. Those need to be physically protected. Think about your computer screens. Do they lock within a short period of time, or do you have one of those dark covers that go over them so that people walking by don't see them? Your screensavers need to be password protected. And of course, servers and mainframes need to be in a secure area where physical access is controlled. Disciplinary actions. Individuals who violate these policies that we're talking about will be subject to appropriate disciplinary action. That's up to and including termination of employment or of their contract. And of course, as Debbie and I both have mentioned, there are possible criminal and civil penalties that can be imposed by authorities. Here's a list of sort of some final do's and don'ts or best practices, reminders. Do when mailing documents, make sure no sensitive information is showing through the envelope window or anything like that. Don't use unsealed mail envelopes when sending sensitive information to another employee. Maybe somebody's working at a satellite office and they're going to, oh, while you're going there, please take this envelope to so and so. Well, make sure it's sealed if it involves protected health information. Do follow procedures for the proper disposal of sensitive information, like we've talked about. When you're sending an email, do not use PHI or other sensitive information like social security numbers unless you have the proper written approvals. And of course, you need to use encryption if it's going outside of CPI's VPN. Okay, that takes us, that we are at the end, and I will see how we did on time. Drum roll. Right at an hour and 3 minutes, so just a little bit over. It was our pleasure to cover this material with you. I want to thank Debbie Heiser for her expertise and sharing her great information and experience, and also a big thank you to Capital Pain Institute, to Dr. Shockett, to Jessica Levy and Lauren for inviting us to provide this training. As I mentioned at the beginning, there will be a quiz that's distributed. I hope you all pass with flying colors, and of course, in the meantime, we would be delighted to answer any follow-up questions you have. And with that, we will sign off. Debbie, thank you for participating.
Thank you, Lorinda, and thank you guys for listening.